Hi everyone, my name is Jhanna Sahijwani and we are back with Law Wednesdays presented by IMS Gets at Law. The topic for today's discussion is the new criminal law bills which have been introduced in the parliament. So in today's session, we will see that how these new criminal law bills will affect the criminal justice system of India and how they are going to be developed in the due course of time. So let's look at that. Firstly, let's understand कि ये जो क्रिमिनल लॉ बिल्स हैं ये क्या हैं. ये जो बिल्स हैं they were introduced by our Union Minister Mr. Amit Shah on 11th of August 2023 in the Parliament as mentioned earlier, and they will revamp three most important legislations. First is the Indian Evidence Act of 1872, which will be renamed as the Bharatiya Sakshya Bill or Act of 2023. Second is the Indian Penal Code of 1860, which will be replaced and revamped as the Bharatiya Nyaya Sanhita 2023. And last is the Criminal Procedure Code of 1973, which will be revamped as the Bharatiya Nagrik Suraksha Sanhita 2023. So ये जो तीनों bills हैं ये recently introduced हुए हैं parliament में. These will obviously be deliberated upon. There will also be a discussion with the public and there will be certain views that will be taken, and after proper deliberation and after proper consideration of each and every element, these bills might actually be passed and they will be considered as the new criminal laws for the country. तो अब हमने ये समझ लिया कि ये बिल्स क्या हैं. अब हम समझते हैं कि इसकी नीड क्या होती है और क्यों ये आइडिया आया कि ये बिल्स या ये एक्ट्स को रिप्लेस करके रिवैम्प करना चाहिए. So to understand the need for three bills, we need to know first and foremost that these all three legislations, which is your IPC, CRPC and the Indian Evidence Act, are all from the British era. They were developed and enacted and put in place in the country, in India, since 1860s, 1872 and 1973 as we looked into earlier. तो आप समझ सकते हैं कि ये legislations काफ़ी outdated हैं. They do not take into consideration the current needs of the society, how India has developed, and which is why we have seen a lot of amendments happening in the current format of the legislation of IPC, CRPC specifically. हमने recently बात की थी of things like the Criminal Law Amendment Act of 2013 या फिर जैसे decriminalization हुआ है of provisions with respect to homosexuality and adultery. So to take into consideration the modern and dynamic needs of the society, we need to have a revamped criminal justice system. Second is the advances in technology. Today, as we speak about, as we do this discussion as well, we know that how technology is important. आज कोई भी काम बिना technology के लिए नहीं हो सकता. But ये जो legislations हैं, they have not taken into consideration the advances in technology for obvious reasons of them being very old and outdated. तो इन टेक्नोलॉजिकल एडवांसमेंट्स को कंसिडर करने के लिए ये बिल्स और ये एक्ट्स बहुत इंपॉर्टेंट होंगे, बिकॉज इनमें कई प्रोविजंस हैं वेयर देयर आर जजेस हु आर गोइंग टू बी अलाउड टू टेक सम एविडेंस इवन इन डिजिटल फॉर्मेट टू द एक्सटेंट ऑफ व्हाट्सएप, SMS एंड थिंग्स लाइक दैट, जो कि आज हमारे एविडेंस एक्ट में अवेलेबल नहीं है. सो ये एक बहुत इंपॉर्टेंट चेंज होगा जो ये क्रिमिनल लॉ बिल्स लाएंगे. उसके बाद द मैनर इन विच द एविडेंस इज कलेक्टेड एंड प्रेजेंटेड. आज भी हम कई जगहों पे डिजिटल रिकॉर्ड्स पे रिलाई नहीं करते हैं. वी स्टिल रिलाई ऑन द पेपर पेन बेस्ड रिकॉर्ड्स, which are obviously very problematic in terms of the fact that they can be destroyed easily, they can obviously be changed, and they cannot be taken care of in the due manner as we can take care of evidence presentation in today's manner or collection in today's manner, because it is easier to protect any form of digital data by way of different softwares and technologies, but to protect a paper pen based data is not that easy. So to eliminate that also, there is a need for this. Then comes the fact that there is a lot of punitive approach that is there. जो हमारा current legislations हैं वो सारे imprisonment या fines या penalty की बात करते हैं, but there is no discussion about things like community service or some voluntary actions that can be undertaken. तो ये जो नए acts हैं वो इनके बारे में भी बात करेंगे, और जब ये implement होंगे तो ये बहुत important होगा ताकि हमारी काफ़ी चीज़ें जो इंडियन सिस्टम में विद रिस्पेक्ट टू प्रिजन्स, द जुडिशरी एंड ऑल द पेंडिंग things that are there that can be taken care of, which comes to another thing that there are umpteen number of cases which are still pending before the courts. तो ये जो particular bills हैं ये बहुत सारी ऐसी बातें करते हैं जिससे आउट ऑफ कोर्ट सेटलमेंट हो सकता है, जिससे हम ये इंश्योर कर सकते हैं कि जो ऑफेंडर्स हैं, स्पेशली व्हेन इट कम्स टू स्मॉल ऑफेंसेस ऑफेंडर्स, इनको कम से कम सज़ा मिले विच इज़ ऑफ डिफरेंट काइंड्स, नॉट जस्ट रिस्ट्रिक्टेड to imprisonment or penalty of a particular kind. So this will help in that direction also. Then, like, we know that there are a lot of conviction rates which are very reduced or very low, which this bill ensures that doesn't happen. We know of certain such offenses which have been very grave and very heinous, which have been committed by criminals in this country, specifically against women and children, and unfortunately they do not receive the due punishment that they should, because the law does not allow the same. So to give that scope to the judges to ensure that there is harsher punishment, stricter punishment, which is given to the criminals who are accused and who are actually guilty of these heinous crimes, that proper punishment is what they deserve, and that is what should be given. So this particular bill also allows for the same. Then comes the issue of gender insensitivity. Now, आज जो हमारे सारे criminal law acts हैं, be it IPC, CRPC or the Evidence Act, they are not very gender sensitive in nature. For example, there is no discussion about the third gender, which is the transgender. यहाँ पे सिर्फ he या she की बात होती है, they की बात बिल्कुल नहीं होती है. So the hope is that with these new bills in picture, we will also include things like any crimes that are committed against the third gender or the transgender people, so that their needs are also taken care of. Then comes the issue of public perception and the lack of victim focus. आज भी हमने देखा है, given the fact of principles of natural justice and the need to prove any crime beyond a reasonable doubt or the guilt of the accused beyond reasonable doubt, we take ages to finish and come to a conclusion, which is obviously needed, because when we talk about principles of natural justice, they're important for any criminal justice system. But this also does not help the victim. This in fact makes the situation of the victim way worse. The public also does not understand. The perception is very different. The fact that we hear day in day out that the judiciary is not doing anything, or our prisoners are not treated in a manner that they should be. So to avoid all of these perceptions, to avoid the fact that victim is not taken care of or focused upon, ये bills ensure करेंगे कि ये सब चीज़ें eliminate हो सके, and which is actually the need of the hour. Last and important thing is that there are certain investigations where there is poor quality which is there, and the prosecution is also of poor quality in nature, and upon all of that there is a lot of human right violations that we hear and see about. So for example, we see or hear about things like third degree torture in the prison which is done by police. Now we don't know how far this is true, but we've read a lot of cases where this has happened, even when there are laws which protect them. However, this continues to happen. Even when it comes to investigation, the police or different investigative agencies do not have a lot of power. If they have the power, there is a possibility of misuse. So to curb all of this and to ensure that all these things are taken care of from a human rights perspective as well as development of the society perspective, these new bills have been introduced, which we strongly believe is the need of the hour. Alright, so now let's look into the first legislation, which is the Indian Penal Code, and इसमें क्या changes हुए हैं. तो सबसे पहले जैसे मैंने बोला, Indian Penal Code would be known as the भारतीय न्याय संहिता Bill or Act of 2023. So the first and foremost change that we have seen is the nature of offense and the definition that has changed specifically with respect to terrorism and other grave offenses. So now terrorism is something which is actually defined in the Indian Penal Code, or as we will know it as the BNS Bill of 2023. इसमें not just terrorism but any acts of waging war or any acts of internal disturbance against the country, if that is done, or who will be classified as a terrorist, is all that is laid down under specific sections, which will help us prosecute and lay down charges in a better manner, not just in the charge sheet but in terms of during the prosecution as well. So this is one very important change that was much needed in the country. The second is repealing of the offense of sedition. Now this is a little confusing as per the current draft of the bill, that sedition is technically not there as the offense that it is laid down under the IPC under section 124A. However, there are certain ways in which sedition still exists, where if there are certain actions which are undertaken to excite or incite the audience against the government, but the kind or the nature of it has changed. In fact, the definition of it has also been changed. So we can see that it is not available, or it is not there in the direct same manner that we currently know of it in the IPC. Then one very important thing that has happened is the prescription of capital punishment for mob lynching, which is the maximum sentence that is available. Now, mob lynching, as we understand, is something we've been seeing very recently, that there is public at large who goes ahead and harasses individuals, especially women and children. So to avoid all of that, and if suppose an individual is caught doing that crime, then in that case, if that is really heinous and grave in nature, उसको एक्चुअली कैपिटल पनिशमेंट की सज़ा हो सकती है, जो कि हमारे किसी भी लॉ में सबसे ज़्यादा सेंटेंस होता है, या मैक्सिमम सेंटेंस जिसे हम कहते हैं, दैट इज़ हाउ इट्स गोइंग टू बी, which is again a very fresh and required change. Then comes the proposal for 10 years imprisonment for sexual intercourse with women on the false promise of marriage. Now this is something again we have seen in the last 10 to 15 years especially, that a lot of cases have been filed by women that men have actually undertaken sexual intercourse with them, or entered into sexual intercourse with them on the false promise of the fact that they will get married to them. तो इसको लेके आज तक हमारे किसी भी लेजिस्लेशन में कोई भी ऐसा था नहीं जहाँ पे ये बोला गया था कि ये क्राइम है, but this is for the first time that this BNS bill is talking about it, and not just talking about it and defining it as an offense, but laying down a 10 years imprisonment as a sentence or as a punishment, which I believe strongly is much required given जितने हमने cases देखे हैं in the past regarding this particular subject matter. Then comes the introduction of community service. Like I told you, हमारा जो current draft of IPC है उसमें सिर्फ imprisonment या penalty की बात होती है, but we do not talk about things like community service. And this is going to help us in two ways. First is to reduce the number of prisoners or the accused in our prisons. As you know that the prisons in India are completely jam-packed. The situation is horrible. The treatment is not that great because unfortunately there is no space, there is no infrastructure to take care of the prisoners. And secondly, obviously there are certain crimes or certain offenses where they may not be as grave or as heinous, or there might be first-time offenders who haven't committed or intended to commit the offense which is in question. So to take care of all of this, community service as a punishment has been introduced, where they can be given certain specific hours of punishment as community service, where they have to take care or give back to the society, which is a very prevalent system that we see in US, Germany, UK, but has never been happening in India. So that's another thing which has been introduced by this particular bill. And last is that it fixes a maximum limit of 180 days to file a charge sheet. तो ये पहले नहीं था हमारे उसमें, but ये अभी change हुआ है with respect to filing of charge sheet. पहले it had to be done immediately or within a period of 90 days, but that has also been changed and more time has been given. Now you may think how this is going to help us, but it's very important because of the fact that there are certain crimes or certain offenses where, especially offenses against women or children, that they do not realize that they actually want to file a case or they're too scared to do the same. So that is something that this particular bills allow us, that there is a 180 days period for filing of the charge sheet. So all of this is obviously a fresh change for the Indian Penal Code. Let's see how this is going to be implemented. अब हम बात करेंगे the changes in the Code of Criminal Procedure of 1973. Like I told you earlier, this is now going to be named as the Bharatiya Nagrik Suraksha Sanhita Bill of 2023 or the act once it's eventually passed. Now let's look into the changes here. फर्स्ट एंड फॉरमोस्ट इज द प्रमोशन ऑफ यूज़ ऑफ टेक्नोलॉजी. तो जैसे मैंने पहले बोला कि जो हमारे करंट लेजिस्लेशंस हैं they do not take care of the fact that we have actually advanced in the technological fields. We have actually a lot of ways in which evidence or other forms of collection of summons or something with regards to notifying the courts or notifying the victim or any of the parties which is there can be done. So this particular bill actually allows for that. It allows for not just summoning people through WhatsApp or SMSs, but also collecting any form of data or evidence when it comes to use of technology. So that's another great change that we see. The second important change that is brought about in the Code of Criminal Procedure is the fact that video recording of statement of survivors of sexual violence is now compulsory. तो आज जो हमारा करंट लेजिस्लेशन है उसमें ये प्रोविजन एग्जिस्ट नहीं करता, बट दिस इज़ वेरी इंपॉर्टेंट बिकॉज जो सेक्सुअल वायलेंस वाले सर्वाइवर्स हैं दे हैव अ लॉट ऑफ डिफिकल्टी इन गिविंग देयर स्टेटमेंट एंड गिवन द करंट सिस्टम they have to probably again and again repeat what they have gone through even before the police, even before the judges. There are a lot of times when there is cross examination that happens which actually makes it very difficult for these survivors, and in order to ensure that they do not have to bear the brunt of it or reiterate their statements again and again, this is a very important provision which will help actually these survivors to ensure that they are not going through that pressure or not going through that same kind of tolerance that they have undergone. So that's another thing which is very important. Now the other thing is that there is a mandate that is laid down on the police to inform about the status of complaint in 90 days. So if there is a complaint that has been filed by any of the parties, they have to inform the status of the same to the parties who filed it within 90 days. आज ऐसा होता है कि हम पुलिस के पास जाते हैं, हम अपना चार्जशीट FIR या कंप्लेंट फाइल करते हैं, उसके बाद द पुलिस मे टेक इट्स स्वीट टाइम to come back to us with respect to what has happened. However, now given this bill, it is compulsory for the police to inform the status of this as to what is the progress, whether there is actually somebody with respect to who's committed the crime has been caught or not, what are the leads with respect to the investigation. All of that is required to be informed within 90 days. So this is another fresh change that we see. Now, the current section 41A of the CRPC talks about the notice that the police officer has to be given in case an arrest is not made. So there are a lot of situations that we see where there is a cognizable offense that an individual has committed, where there is arrest which is not necessary. So in circumstances may the police officer can ask this accused to make an appearance at regular intervals before them. So this provision in the current CRPC was as an amendment which was added, but under the BNSS it will be under section 35 as an important provision. Then comes the police's power with respect to consultation of victim before withdrawing a case. So अगर कोई भी केस फाइल किया गया है किसी इंडिविजुअल से जहाँ पे 7 years और मोर का punishment of imprisonment है, so then in that case if the police is withdrawing the victim's complaint or the FIR that has been filed, there is an appropriate consultation that is required to be done, and that consultation has to be made a part of the official records. Only then the police can do so. The police cannot do it within their own accord or when they deem fit कि अब हम इसको withdraw कर सकते हैं. So this is a power that was earlier there with the police, but as a part of the BNSS has been taken away from them. Another important change is that the absconding criminals can now be tried in absentia. So when I say that there can be trial in absentia, which means कि अगर ये जो accused है, who's been accused of a particular crime, अगर वो country में नहीं है या state में नहीं है और वो बार बार appearances में नहीं आ रहे हैं when the date is given by the court, then the court actually has the power to undertake the prosecution or the trial without their presence. हमने आज बहुत सारे cases देखे हैं जहाँ बहुत renowned criminals or accused as we know them like Dawood the Ibrahim are actually in another country. We know where they are, we know what they are doing, yet they are not making an appearance. And since they are in an international territory, we have no power to lay down any form of punishment for them. But this particular provision allows for an in absentia trial, which means कि उनकी presence के बिना भी trial हो सकता है, and अगर the court decides for a particular term of imprisonment or punishment, they will do so, and this will help the police or the investigative authorities to go ahead and catch that individual and bring them back. So this is the power which will be given to the police in terms of this particular trial in absentia provision. So this is another thing which has been added. Other thing is the power of the magistrate to take cognizance based on electronic records. तो आज जो magistrate के पास powers हैं, they can only take cognizance of the matter, or they can undertake the matter only and only when there is a proper hard copy of the evidence that is there. But now as per this provision, हम electronic records दे के भी magistrate से या police जो magistrate के पास जा सकते हैं, और they can ensure that that case is taken into consideration, so that the time with respect to arranging for hard copy evidence is eliminated and the matter can be disposed quicker. So this is another thing that has been added, along with the fact that mercy petitions are now to be filed within 30 days to the governor and within 60 days to the president. So mercy petition is nothing but essentially a pardoning power that is given to the governor and the president, especially in cases of death penalties. So आज अगर किसी भी इंडिविजुअल को डेथ पेनल्टी सेंटेंस दिया जाता है, तो वो गवर्नर या प्रेसिडेंट के पास जाके उनसे एक मर्सी पिटिशन की रिक्वेस्ट कर सकते हैं, सो दैट दे आर नॉट गिवन द डेथ सेंटेंस, बट रादर देयर punishment is reduced to say a life imprisonment or some other kind of punishment. Now there was no limit to when this petition can be filed, but as a part of the BNSS bill of 2023, this has to be filed before the governor within 30 days and before the president within 60 days. So the last change now that is there is that there will be no appeal against the president's decision in any court. So agar the decision of the president has been, like we spoke about in mercy petitions, कि उनको grant नहीं दिया जा सकता about the fact that the death sentence should not be executed. If something like that is what the president decides, there is no possibility that this individual can go back to the Supreme Court or the High Court of any kind in order to change this. So this is another important change. These are all the changes which are being suggested in the CRPC in order to ensure that the trial and arrest of an individual is done in a proper and structured manner. Alright, now we'll look into the changes that have been suggested in the Indian Evidence Act. So this act will now be known as the Bharatiya Sakshya Bill of 2023. What is it going to change is, first and foremost, is that it defines what an electronic evidence is. Yes, आज जो हमारा Indian Evidence Act का version है, उसमें electronic records, electronic evidences की बात तो की जाती है, but there is no definition which talks about what this term electronic evidence would entail. So this particular legislation or this particular bill will go ahead and talk about it, and it would include things like any form of evidence which is collected through electronic means like Instagram, Facebook, WhatsApp, SMS, or any videos that have been created. So this is something which has been added under the Indian Evidence Act, or as the Bharatiya Sakshya Bill of 2023. The second change is that there is a specific criteria for admissibility of electronic evidence. तो आज जो हमारा, like I said, electronic evidence का format है वो बहुत ही skewed है, उस पर कोई clarity नहीं है. So with the fact that there is a definition added to it, there is also a specific criteria as to what can be admissible. So there is a specific guideline which says that, okay, you know, if an electronic evidence is produced, what is it that should be taken into consideration, how it should be detailed in the manner that the court can actually take it into consideration as an evidence. The third change is that there is a special provision for admissibility of DNA evidence. तो अभी तक जो DNA evidence था उसके बारे में allowed था, उसको लेके हम provisions बना सकते थे, like the courts could actually go ahead and take it. But now the Indian Evidence Act actually allows for it. It says how the DNA evidence can be collected, how it can be filed, whether and to what extent will it be made admissible. This is something which does not exist in the current version of the Indian Evidence Act, but will now be included under the Bharatiya Saksha Bill of 2023. The fourth change is that expert opinion is now recognized as a valid evidence. तो आज जो हमारा practice है with respect to the courts, they do take into consideration expert opinions of certain forensic experts, medical experts, or any other experts with respect to, say, guns or any other ammunitions that may be there, in order to understand what kind of crime has been committed and the different nuances of the crime. But this was something which was not there as a part of the Indian Evidence Act, but this is now recognized and is defined under the Bharatiya Saksha Bill of 2023, ensuring that expert opinion forms a part of trial or evidence collection. And the last change is that there has to be a presumption of innocence as a fundamental principle when we look into the overall criminal justice system. आज ये हम obviously बोलते हैं कि when a crime is committed, anybody who is accused of it should not be declared guilty till the doubt of that individual is proved beyond reasonable doubt, or the fact that that individual has actually committed the crime or not is something is proved beyond reasonable doubt. But this is something which is nowhere laid down in any of the legislation. This is something which we were just following as a principle of morality, but now it is a part of the Indian Evidence Act, which makes it a fundamental principle or is at the core of our criminal justice system to ensure that the treatment that is given to the accused is fair and they are not treated as an outsider, or they are not declared guilty even before the courts can do so. Now let's look into the fact that what are the challenges that are going to come with these changes. So first and foremost is obviously opposition and resistance. जब भी कोई change आता है किसी भी country में, we have noticed that there is going to be opposition and resistance, not just from a particular group of people but from even the entire country, जो कि बहुत normal है, because this is going to lead to a huge transition. Some of the transitions may be good, some may be bad, some may affect some group of people, some may not affect some group of people, but ultimately there is going to be some opposition. But as we know that if these changes are good in nature, this is actually going to be helpful for the country and the criminal justice system at large. So I think it's time we look at it from a fresh perspective. We see the goodness that is involved in it rather than focusing on the problematic bits of it. Then comes the legal challenges and scrutiny from courts. आज जो हमारा legal system है, especially जो judiciary and police officers हैं, उनको बहुत टाइम से एक प्रॉपर सिस्टम की आदत है, एक स्ट्रक्चर की आदत है, जो कि विद दीज बिल्स इन पिक्चर काफ़ी चेंज हो सकता है. सो for them to actually adapt to this will take a little bit of time, but like I said, any transition takes that time, and the idea is to focus on how these transitions can be incorporated rather than actually completely being against them. Also, like I said, the practical difficulties that may come with the fact that today you and me are aware of things like rape is coming under section 375, murder comes under section 300, but this will obviously change. But ये सिर्फ knowledge awareness की बात है. Once we all try and understand and look into these draft bills which are actually publicly available and accessible, तो आज आप इस वीडियो के बाद जाके actually गूगल करेंगे तो आप पूरा का पूरा ड्राफ्ट देख सकते हैं. आप खुद देखिए, आपके आसपास जो लोग हैं उनको दिखाइए, ताकि लोग अवेयर हो सकें, उनको समझ आ सके कि उनके क्या राइट्स हैं, उनको क्या ज़रूरत पड़ सकता है, so that they are protected and obviously they are open to the idea of these new bills. So that's another thing, and there can obviously be certain unforeseen complications. One very important complication that I see is the fact that when we are talking about data protection, आज obviously हम बात कर रहे हैं how electronic evidences, how electronic records need to be more and more prominent in the criminal justice system, but with it comes a lot of issue or lot of question on the security. आज अगर हम as a court या as a police officer ईमेल आईडी, फ़ोन नंबर्स कलेक्ट करते हैं और अगर इसको इलेक्ट्रॉनिकली स्टोर करते हैं एंड वी स्टोर इट फॉर अ लॉन्गर पीरियड ऑफ टाइम, there is obviously a possibility of some form of hacking that may be there, or this data being lost in some or the other manner. But we also need to keep in mind that the Data Protection Act is coming into picture, which will take care of these privacy and security concerns that we have. So it's time कि हम इसको एक fresh perspective से देखें. We try and understand the good and the bad of it, and obviously we have to rely on the fact that this change is going to be important and much needed for the society. Now, before we conclude this, I want to remind you of the CLAT Challenges series that is ongoing at this point of time, where IMS Gets at Law gives you the opportunity to avail certain cash prizes for 3 different tests. Out of that, 2 of them are going to be coming very soon. So please apply for the CLAT Challenges series, and the link of that is given in the description below. I hope that this video was helpful. इसके बारे में प्लीज़ अपने और आसपास सबके साथ शेयर करिए ताकि ज़्यादा इन्फॉर्मेशन, ज़्यादा अवेयरनेस बढ़ सके. For more such videos, please stay tuned to the IMS Gets at Law channel. Thank you, bye bye, and all the best.